Good morning, PrepAgent land. This is Adrian from PrepAgent, welcoming you to today's webinar on contracts. If everybody can hear me, go ahead and type your city and state into the chat. This does two things. This lets me know that y'all can hear me and I'm not just talking to myself. And then it also gives y'all the opportunity to see if there's anybody else in your area, to see if there's anybody who's studying the exact same stuff you're studying. And we've seen a few study groups get put together because of this. So this is our new morning ritual. Ooh, good luck to Kimberly Giles. Test on 11/21. Second time is hopefully the charm. Morrow says he's 3 points away. That's pretty close too. Hope that's coming. Hope that's coming soon for you. All right, looks like everybody can hear. Again, hope everybody's having a great morning. You brought your briefcases. We're talking legal stuff today, contracts. Good luck to Janessa Lerma with an exam coming up this Friday. Whenever I think briefcases, is anybody old enough to remember the infamous Brady Bunch courtroom drama where Mr. Brady threw his briefcase and completely undid a fraudster's case? I think that is the basis for all good legal dramas. Hello to Cynthia Johnson from Texas. It looks like we've got a good crowd. So let's go ahead and get started with the 4 essentials of a valid contract. The basics of basics with contracts. What are the 4 essentials of a valid contract? Hello to Irum from Seattle, Washington. I have lived in Seattle before. Beautiful area. Love it. So again, 4 essentials of a valid contract. Rachel Hahn says mutual consent, capable parties, legal object, and consideration. Very, very true. So mutual consent is often called offer and acceptance. There are actually 3 parts of offer and acceptance. I think they're all very important. Can anybody tell me what all 3 stages of offer and acceptance are? And Brandy asks, does anybody have a method for remembering the 4 essentials of a valid contract? The best one that I have seen, Brandy, is CLOC, C-L-O-C. And that is if you look at capable parties, lawful object, offer and acceptance, and consideration. That spells CLOC, C-L-O-C. And for the 3 parts of offer and acceptance, we're talking about offer, acceptance, and communication of the acceptance back. Very important. We will touch on that. So for today's webinar, we're going to do a bunch of questions that y'all probably know the answers to. So we'll be able to feel good about that. But the reason that we're going to do these questions is because all of them have a little bit of splaining to do to understand why they are what they are. But just real quick, before we launch into that, the other thing that I find important is for us all to remember why we're studying this. Why are we studying contracts for real estate? Why are contracts important? So what I would like is for everybody to throw up an example of a type of contract that we use in real estate. There are a bunch of them, but can everybody throw up as unique a contract as you can think of? Try and be as different from everybody else's answers, but what are some types of contracts that we use in real estate? Ooh, Deb threw a nice one up early. Leases. Morrow says an exclusive right to sell. Exactly. So listing contracts are also contracts. Mark Newman says a purchase contract. That's a big one, right? Joe says that the purchase contract is our roadmap to closing. Kind of tells us everything that needs to be done. for us to close on a deal. So that's super important. And the rest of them are mostly like listings, leases, things of that nature, right? So that's why we're studying contract law with real estate. You need to know just the basics because you will be dealing with contracts, and your broker in particular, or when you become a broker or managing broker or broker in charge, depending on your state, you will actually be doing even more with contracts. All that being said, you guys do deal with contracts all the time. Is that going to make you lawyers? Is that going to empower you to provide legal advice? Does this contractual understanding that we are studying today give you the position and authority to give legal advice? Rachel and Carrie say no. Shanita and Tanya agree. Even though we're studying and you're going to learn a lot about contract law during this process, that does not give you the authority to give out legal advice. And as much as possible, you want to stay away from that because, as you've probably discovered, legal stuff is really sticky and squishy, and there's lots of exceptions to it. And you don't want to put yourself in that situation if you can avoid it. Everybody seems to agree, so that is a great place to jump into the questions on the board. First question: Henry made an offer to purchase real property. However, he died of a heart attack before the listing broker could notify him of the signed acceptance by the seller. Based on these facts, which of the following is true? Is it A, notification to the administrator or executor would bind the estate? B, the offer and acceptance constitute an enforceable contract? C, all the other options are correct? Or D, the death of Henry constituted a revocation of the offer? What does everybody think here? Amelia Cruz says always recommended to look for the professional advice. That is absolutely true. So Joe talked about it earlier this week. If you walk into a house, if you're sort of looking at a house that you're getting ready to list for a seller and you notice a big crack in the wall, is it your sort of responsibility to determine why that crack is there, to start talking about, this shows some structural weakness in the foundation. I think maybe we need to shore this up. No. If you're showing a house and you see a crack in the wall, or if you're inspecting a house, you see a crack in the wall that's not listed as a material fact, what your responsibility would be is just to bring it up and recommend that a professional is called in. Same thing when you're talking legal advice. If somebody is asking you for more than just general advice on how much maybe their home could be listed for or something like that, like if somebody's asking what type of seller financing they should do, probably not in your best interest to recommend anything to them. You want to refer them to a lawyer. So back to the question on the board. Henry made an offer to purchase real property. However, he died of a heart attack before the listing broker could notify him of the signed acceptance by the seller. Based on these facts, the death of Henry constituted a revocation of the offer. So everybody who threw up an answer on the board, it looks like got this right, and that is awesome. But just to clarify, the reason that this is correct is because of what we talked about before, with there being three parts to offer and acceptance. There's offer, there's acceptance, and there's the communication of the acceptance. So in this particular case, Henry was not, communication of the acceptance did not get made to Henry, and so he cannot be held to the contract. And that's basically how I always look at this is, should Henry be held to an agreement he didn't know he was making? No, he didn't know that his offer had been accepted, so his estate should not be held to the contract. Hope that makes sense to everybody. Welcome Deborah from Merrillville, Indiana. A little Hoosier action going on. And let's move forward. Avoidable contract is a contract that A, was valid at the time that it was signed, but for some reason cannot be proved or sued upon by either or both parties. B, has no legal effect because it really is not a contract. C, is valid and enforceable on its face, but it may be rejected by one of the parties. Or D, contains all of the legal essentials required for its existence. And Mira asks, what would have happened if Henry had died after receiving communication of the acceptance? So if Henry had been notified that his offer had been accepted, then at that point you have a valid and binding contract. You have all four of the essentials that we talked about earlier, the CLOC, capable parties, capable parties, lawful object, offer and acceptance, and consideration. And so at that point, Henry would have had a valid offer and his estate would have likely been compelled to follow through with the contract. Back to the question on the board, avoidable contract is a contract that is valid and enforceable on its face, but it may be rejected by one of the parties. So it has all four essentials of a valid contract, but for one reason or another, it may be rejected by one of the parties. Can anybody throw up an example of avoidable contract? What are the types of avoidable contracts that we talk about a lot when preparing for the real estate exam? Any ideas, any suggestions, any thoughts? We are talking about a voidable contract that is different from unenforceable. So Marta Grissom says duress. Duress is a huge one. Julian Guzman says age. That is another big one. Rachel Hand says must be in writing and is not. I'm going to disagree with you there, Rachel, and say that's going to make a contract unenforceable and not voidable. So if a contract needs to be in writing because the statute of fraud says that it needs to be in writing, if it doesn't have that, then suddenly it's missing an essential for the type of contract that it is. And so it's not voidable because it was never fully valid. Instead, that makes it unenforceable. I hope that makes sense. And this is kind of what I was talking about with how so much of contract law is a little bit squishy. Carrie is buffering. So I'm going to tell Carrie to try refreshing your screen if buffering, or restart your browser and get a new link. Carrie is back. So Feng Wu asks, what's the difference here between A and C? A, that it was valid at the time that it was signed, but for some reason cannot be proved or sued upon by either or both parties. That would be sort of a situation that's halfway between unenforceable. And so what we're getting at with A here is something that is like maybe a statute of limitations that surrounds the contract has expired, or some other component of the contract is no longer valid, and that makes the contract unenforceable at that point. The difference with a voidable contract is that it has all four essentials of a valid contract, but because of something like duress or because one of the parties was a minor, it can be voided by one party. So the difference between unenforceable and voidable is that an unenforceable contract, if you take it to a court of law, they're going to say we can't enforce this. A voidable contract has one party that can actually void the contract. So it's a minor difference, but it is a real difference. Hope that makes sense to everybody. If not, let me know in the chat and I'll try it again. Oh, good luck to who? Good luck to somebody's taking the exam. Sheila. Good luck, Sheila. Taking the exam soon. This is a great thing to be doing before then, a little bit of review, and also spend some time reviewing your vocabulary. Just make sure everything's fresh in your mind before you go in tomorrow. Moving right along. Under a sales contract, the legal remedy that may be used to force the seller to consummate the sale is called A. Specific performance, B. A writ of execution, C. An unlawful detainer, or D. Foreclosure. Good luck to you too, Jesus Acosta. Nice, lots of people taking the exam this week. So good luck to you all. And what do you think about the question on the board? Under a sales contract, the legal remedy that may be used to force the seller to consummate the sale is called specific performance. And there's some confusion on this one. So specific performance is what a buyer can sue a seller for to make them follow through on a purchase contract to make them sell the house. For those of you that confuse that with a writ of execution, a writ of execution is a court order that empowers somebody like a sheriff to follow through on a sheriff sale, or it empowers foreclosure to proceed. It basically, a writ of execution empowers an entity to follow through on a judgment, usually. Rachel says, after a court judgment. Exactly. Mark Guzman asks, what is consummate? Consummate means follow through with. Essentially, consummate has a few different meanings, but you hear it a lot with consummate a relationship, and that means like sort of strengthen or validate a relationship. So consummate the sale basically means to force the seller to follow through with the sale, to complete the sale, to validate the sale. Makes sense to everybody? It looks like we mostly make sense there. Now this is exactly why I wanted to throw this question up here, because it's a little bit tricky, you know. A writ of execution is very similar to the definition for specific performance, which is to force somebody to do something. All right, so next question on the board. Which of the following would usually occur in a sale and leaseback transaction? Is that A, the rent that the seller pays is not income tax deductible, B, the seller gets a return on the purchase in the form of rental payments, C, the buyer keeps capital in inventories rather than in realty, or D, the property is sold on the condition that the new owner lease it back to the seller at the time title passes. And the last question, Marta Grissom says consummate equals executed. In the terms that we're talking about, yes, I think that is correct to say, Marta. Good call. Nice, you guys are killing it this morning on the questions. Which of the following would usually occur in a sale and leaseback transaction? The answer is D. The property is sold on the condition that the new owner lease it back to the seller at the time title passes. Julian Guzman asks, why would anyone do this? Does anybody have an idea of why somebody would do this? What is an IRL situation when a sale and leaseback transaction would occur? Tania Gilbert says if they can't find a home in time. That's potentially a time when you would do this, but it's not the most common. Marta Grissom hit the nail on the head with investment. So it's closer to an investment in the sense that for the seller, it allows them to free up capital. Ooh, Malou hit it a little bit closer, increases capital. So it doesn't increase capital investment, it actually increases liquid capital, right? So liquid capital just being capital that can easily be translated into either cash or into other improvements that you need. So the most common thing that I hear about is if you have, say, somebody in a manufacturing sector, somebody is producing some sort of manufactured good, and they really say they need to buy a new $350,000 packaging machine, but they don't really have those sorts of assets, but they did happen to purchase the building that they installed their business in. Because they purchased the building that their business is in, they're paying things like property taxes. They're paying on things like depreciation, upkeep, maintenance, all of these different sort of expenses that you have with property ownership. But really, he doesn't need that to run his business, right? He doesn't probably need the property to run his business. And if he or she decides that it's in their best interest to get, say, $750,000 for selling the building now and then reinvesting that in the business, but they still need to occupy the space that they're in because that's where all their equipment's set up. That is normally when somebody is going to do a sale and leaseback. Does that make sense? So it's basically they want to take the money that they have invested into the property and convert that into funds that they can invest back into the fundamentals of the business rather than property investment. So potentially like a cattle ranch, but I haven't really heard of it so much like that, Carrie. But hopefully my example made some sense. And that's usually when I hear about it. Feng Wu says that he actually did this when selling their old house and didn't want to move. So there you go. There's a potential, or there's an example of doing this with residential property too. Okay, let's move along. We're going to try and bang through another 10 to 15 questions because we've got a bunch of people taking the exam coming up. So I'm going to speed it up a little bit. But as always, when I'm on the mic here, feel free to throw up questions. I love answering questions. It helps challenge both me and you guys, your brains as well. And that means our brains are active and we're learning when we do that. So always welcome to throw up questions. Question on the board is, which of the following is not a necessary element in the formation of a contract? Is that A, performance, B, consideration, C, acceptance, or D, offer? And everybody agrees that the element that is not necessary in forming a contract is performance. Performance is what happens after you have all four essentials of a valid contract. That makes sense to everybody? Performance is what happens after. This confuses a lot of people. A lot of people confuse consideration and performance or consideration and payment. Remember that consideration is only a promise to pay once the contract has been performed. OB3 says no P in clock. Great call. There is no P in clock. Clock. Just doesn't work as well. Next question on the board. Salesperson Beth took an offer to purchase from her buyer to Broker Smith's office to present it. The offer included a $1,000 promissory note from the buyer as the earnest money deposit. Broker Smith should do which of the following upon receipt of the offer? A, tell Beth she should have called him first as to not waste her time so he could call his seller to see if they would consider an offer with the promissory note. B, tell Beth she wasted her time and that he cannot accept the offer without cash or a check for the deposit. C, tell Beth the note is not good enough because it did not come with a deed. Or D, tell Beth that a promissory note is just as good as cash or check for the deposit and present the offer to the seller. So this one can be confusing because It asks you to choose the most correct answer, and that is still a common question format on many real estate exams. So I've gotten a lot of feedback on this one asking me to clarify, but we specifically don't want to clarify this because to get it right, you have to consider what's really being asked. So the question is that salesperson Beth took an offer to purchase from her buyer to broker Smith's office to present it. The offer included a $1,000 promissory note from the buyer as the earnest money deposit. Broker Smith should D. Tell Beth that a promissory note is just as good as cash or check for the deposit and present the offer to the seller. That is the most correct answer. Now, the seller can still reject the promissory note as a form of earnest money. It's up to them whether they want to accept anything that isn't as liquid as a cash or check, right? But the point of this question is that just about anything of value can be used for earnest money. So we've heard of people using antique clocks or gold or different things like that. If the seller is willing to accept a particular item of value as earnest money, then you're gold. You're ready to go. That's a good faith deposit. So the key word here is earnest money, Deb, and the key concept is that earnest money can be anything of value that the seller is willing to accept. And it looks like we are good there too. You guys, once again, all got that right. So let's try this one. The transferee in an assignment of a lease is called the A, assignee, B, assignor, C, sublessee, or C, sublessor. This is a little grammar. So you're basically looking at your EEOR suffixes and then your root word and trying to match up which one is the same as a transferee when you're talking about the assignment of a lease. So when you're working this through in your head, the first thing you want to do is think about what is an assignment of a lease. Okay, assignment of the lease is to transfer one's rights in the lease. So if you're the transferee, if you're the one transferring the rights, then you are also going to be the assignee. You are the one assigning the rights, or excuse me, being assigned the rights. Spoke that incorrectly. You are the one being assigned the rights in the assignment of a lease, and the assignor is the person giving the assignment of rights. Kimberly dislikes the EEOR rule. I sort of agree, but it's one of the rules, Kimberly, that does not have a, at least that Joe and I have come across, there are no exceptions to that rule, and it's kind of nice to have a rule that you can count on. So really then it just comes about like parsing your grammar once you know that EEOR always applies. Next up, a parcel of vacant land is listed for $100,000, requiring 20% down with the seller to carry back the balance. The broker brings in a full price cash offer, but the owner refuses. The broker is entitled to A, the full commission, B, a commission as a percent of the down payment, C, half of the commission, or D, nothing. What does everybody think here? Kimberly, if you actually watch Joe's video on EEOR and learn the song, which I still have yet to get it down 100%, so I'm not going to share my singing talents with you this morning, but it makes the EEOR thing less annoying because you kind of just have to laugh at yourself when you're singing the song. Gives me property for my pleasure. Wait, no, I already got it wrong. Already got it wrong. I'm going to just keep my mouth shut there. So if a parcel of vacant land is listed for $100,000, requiring 20% down with the seller to carry back the balance, and the broker brings in a full price cash offer, but the owner refuses, the broker is entitled to nothing. So the reason that I wanted to cover this one is because it confuses a lot of people. So the first thing is, why would anybody do this? If there's a full price cash offer, why would the seller refuse? In this case, one reason could be that the seller actually makes interest if they're carrying 80% of the sales price, so $80,000. If they're carrying $80,000 as a loan to the buyer, then they're actually earning some interest off that. So that could be one reason why they might want to refuse. But the more pertinent point is that for the most part, a seller can refuse any offer. A seller can just, they don't have to give a reason, but they can refuse any offer that walks in their door. And except for, there's one contingency that would result in the broker still making a commission if the seller refused an offer. Does anybody have an idea of what that is? What would be the one situation? What is the one thing that could result in you as a broker or agent still earning a commission if you bring in an offer that matches the seller's specifications exactly? Is there anything that you can do to make sure that you earn a commission in that? Any ideas? Ooh, Nisha got really, really close. Nisha got really, really close with prepayment clause. Carrie hit the nail on the head. You can put a clause into your contract, or basically just make it as part of an agreement that says if you procure a buyer that meets the seller's specifics exactly, that you earn a commission regardless of whether the seller accepts the buyer or not. I don't really know if there's a specific name for the cause. It's not quite procuring cause, Denise. You can prove that you're the procuring cause of finding a buyer, but if you don't have a clause in your listing agreement that says you get paid for bringing in a buyer that matches the specifics, if you don't have that clause, the seller can refuse any buyer you bring in and you don't get paid. Somebody did throw up fair housing. If you have reason to believe that the reason they're refusing is fair housing, then you could probably bring a court suit, but that's pretty unlikely. If it's a fair housing violation, it can only be a fair housing violation if you, as the broker, are aware that there are discriminatory reasons that the seller is refusing to sell to a specific buyer. And that can be pretty difficult. So we have some questions like that in your practice exams, and in those questions, the seller is always very obvious about the fact that they're discriminating. But that's kind of a hard one to prove unless the seller says something. So hope that makes sense to everybody. Jennifer Tran says if you have a codicil in your contract, there's a potential there. What's the definition for codicil, everybody? What is the definition for codicil? Snap quiz. Snap quiz on your Latin lessons. So actually, I was getting confused there. Codicil would not help in the case we were talking about, because a codicil is very specifically, as Gretz and Mark said, an addition or an addendum to a will. More so, I think what you were thinking is a novation. What's a novation? Can anybody tell me what a novation is? Novation Jesus says Latin. You didn't know you were getting a Latin quiz in the middle of today's webinar, did ya? Innovation is something new. So that can also be an addendum. It could be a something or somebody that's new in a contract. So you could actually insert a novation into a listing agreement that ensures that you get paid if you find the right sort of buyer. But for the most part, and this is something I forgot to mention with our last conversation, for the most part, you don't earn a commission until the purchase agreement closes. Most standard listing agreements say that you don't earn your commission until the purchase agreement closes. But you could potentially get a seller to agree to a novation. Tanya asks, like a rider in a contract. It could be. A rider is just like sort of an addendum, but it's usually unrelated to the performance of the specific contract, but that could work. Right, so let's do a couple more questions here, and then that's going to be it for today. Days always go so quick. A contract based on a legal consideration is A, valid, B, enforceable, D, void, that was C, void, or D, voidable. So we kind of talked about this earlier. Based on certain factors, a contract can be valid, void, or voidable, or unenforceable. So if you have a contract that is based on illegal consideration, it is going to be void. It is void because you were missing one of the 4 essentials of a valid contract from the get-go. You were missing an essential of a valid contract from the beginning. So it was never valid, which means that it was void. And again, voidable, as we talked about, means that one party, it has all 4 essentials, but one party, either because of duress or because they're a minor or for some extenuating circumstance, has the option to void it. And then unenforceable means usually that something else changed in the enforceability of the contract. And so if you were to go to a court of law, it would be unenforceable. Last question for the day. Let me find a good one. I thought this one was very interesting because I haven't come across this very much, but it makes sense if you just sort of logically look at the answers here. A written purchase agreement has been signed by both a buyer and a seller. The Uniform Vendor and Purchaser Risk Act states that until the buyer has either possession of or title to a property, responsibility for the physical condition of the property, A, remains with the seller, B, is assumed by the seller's homeowner's insurance company, C, is delegated to the buyer, who upon signing has equitable title to the property, or D, is given to a third party. So for most of you, you're probably like me, you haven't come across the Uniform Vendor and Purchaser Risk Act very often, but it kind of makes sense that until the buyer has either possession or title to their property, responsibility for the physical condition of the property, A, remains with the seller. So I looked this up, and basically the Uniform Vendor and Purchaser Risk Act applies to all sorts of things, but this particular part of it applies to real estate as well, and it's basically just saying that, you know, you can't agree to sell your house and then destroy it after the paperwork is signed, but before you give possession over to the buyer. Temerer asks what a Scam Can Act is. I have to admit that I don't know that off the top of my head. So let me take a quick look. Looks like it's kind of a spam act, and it just has to do with how you can sort of communicate marketing emails. So Temerer, probably recommend you do a little bit of Googling on that. It doesn't come up much in real estate exam prep. But if you can't find any good information, just send me an email using the contact form on the website, and I will find an answer for you. All right, that's going to do it for today, everybody. Appreciate y'all stopping by. You did a great job today. Hopefully we covered a concept or two that you hadn't encountered, and you're going to be that much better armed when you go do your exam. Carrie asks when we're going to do math again. I'm hoping, Carrie, that I'll have a new version of the math webinar ready in a couple of weeks. And that'll be it. All right. Thanks so much, everybody. Hope you have a great rest of your Wednesday. Good midweek break for you. Get lots of studying done. And best of luck to everybody who's taking the exam soon. Have a great rest of your day. Take care.